between one, Mr. Usani Etowa, and one, Nigerian Police Force, two, the Inspector General of Police, three, the Chairman, Police Service Commission. My lord, the parties are absent.
Okay. You say parties absent?
Yes, my lord, the parties are absent.
Appearance? 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 Have you served all the parties with the hearing notice?
Yes, my lord, I have proof with me, my lord. My lord, I have proof of service.
Okay.
Supposed to.
Okay. This case is for judgment.
Respectfully, my lord.
Yes. Which matter are you appearing for?
My lord, Chris Okoro, my lord.
That is not the one they call.
Oh, I'm sorry, my lord.
They call another case, which is for
sorry,
judgment. I'm going to read the judgment quickly.
As the court pleases.
This is the judgment of the court. The claimant in this suit took out a general form of complaint dated 10th day of January 2023 and filed on the same date against the defendant. On the 25th day of March 2025, the claimant was granted leave to amend his statement of facts and amended statement of facts, which has the amended statement of fact already filed before the court was being properly filed and served. By the amended statement of fact, the claimant sought for three reliefs. They are: one, a declaration that the unlawful dismissal of the claimant from the Nigerian police force without going through the laid down procedure is unlawful, illegal, and should be so held. Two, an order mandating the defendants to immediately reinstate the claimant into the Nigerian police force and promote him to the rank he would have presently be with his mate, and also pay him all entitlement wages, salaries, allowances from February 2006 when he was dismissed till the determination of this case. C, 03, and for such, and the sum of 50 million naira as general damages for hardship the defendant have caused the claimant. The defendants in this case, despite having been served with the originating processes commencing the suit, failed and neglected to enter appearance or file defense. This means this action was not contested, as it is only the case of the claimant as put forward by him that is before the court. As it can be gleaned from the statement of facts and the witness statement on oath adopted by the claimant while giving evidence in chief, the claimant was a serving police constable before he was unlawfully dismissed from service without being made to go through the normal procedure of orderly room trial. The claimant last posting was Squadron 10, Mobile Police Post Bauchi. According to the claimant, on 21st day of September 2005, he applied for a 4-day casual leave to enable him travel to Cross River State and attend to urgent family issues. The application was approved. The claimant pleaded the application was approved. But while the claimant was on approved leave, he fell sick and was diagnosed with pneumonia and taken to hospital for treatment. While the claimant was on sick bed, he raised a signal from either South Divisional Police Headquarters in Ebonyi State to his squadron commander in Bauchi, intimating him of all of his ill health. The claimant pleaded to rely on the said signal he sent to his commander. Upon being discharged from the hospital on 28th day of March 2026, he was placed on bed rest away from cold and dust. However, the claimant was surprised to hear that he has been dismissed from the service for being deserter on 28th day of February 2006. The claimant, who was still recovering, traveled to Bauchi to his last posting with the assistance of his sister and met with the squadron commander, who said there was no signal sent to them. That's why he was tagged deserter. The claimant informed the squadron commander that he sent the signal from Ebonyi. The signal was later found in the confidential file of the command. The claimant was asked to go back the next day as the information would be forwarded to the Commissioner of Police for necessary action. When the claimant reported the next day, he was surprised when he entered the commander's office. His commander asked him where he was from, and when he said Cross Rivers, at that point he walked him out of his office and called the provost marshal and asked him to follow him to his house and collect his uniform and identity card, which he gave him without any orderly room trial. The claimant wrote letters of complaint, which were tendered in evidence and marked as exhibits C1, C2, and C3. The submission of the claimant, the Itwenu Ukfonu Esquire, counsel for the chief legal aid officer, counsel for the claimant, formulated twin issues for determination. They are whether the claimant has proved his case to merit the prayers claimed on the complaint. 2, whether the claimant is entitled to the claim being canvassed in the complaint. In arguing issue 1, counsel submitted that it answered the further in the positive. That is to say that the claim has proved its entitlement to the relief. So he also relied on Section 131 of the Evidence Act as amended. According to counsel, in the instant case, the claimant has proven his case succinctly on merit, and the claims he is claiming before this honorable court by firstly proving before this honorable court that there was a contract of employment between the claimant and the defendant, and that the defendant violated its own down procedure in sorry, it appears my mic was off. according to counsel before this court, are facts ranging from the complaint to the accompanying affidavit and document that are being tendered that have been tendered to substantiate the claim of the claimant. Counsel asked the court to answer decide the issue 1 in favor of the claimant. On issue 2, whether the claimant is entitled to claim being canvassed, counsel posited that the court would only be bound to accept unchallenged uncontrovertible evidence if it were cogent and credible. The court would also accept pieces of evidence will not accept evidence which is not material or of no probative value, merely because evidence is already before the court. According to counsel, even where the evidence is unchallenged and uncontroverted, the trial court has a duty to evaluate it and be satisfied that it is credible and sufficient to sustain a claim in support. Counsel submitted that in this case, the claimant has succinctly proved his case and has laid evidence to show that he was in employment of the defendant and was unlawfully dismissed without undergoing ordinary trial. In concluding his submission, counsel concluded that this address with the position of the law in the case of Monko versus Odili, which position has it that a trial court has little or no choice but to accept unchallenged and uncontroverted evidence pleaded before it by a claimant if it was not discredited by the defendant. Counsel submitted that, as stated earlier, from the beginning of this matter and from the beginning of this final written address, the defendants have not put any defense, which leaves the court with no option than to accept the claimant's case as put forward before the court, and also accept it as proof for having not been contradicted. Counsel asked the court to accept the case of the claimant and grant the relief sought in the statement of facts. Court decision. I have carefully and painstakingly perused the processes filed in this suit, as well as evidence laid by the claimant, written and oral submissions of counsel for the claimant. The facts of this case are simple and straightforward. The claimant stated that on 21st day of September 2025, he took 4 days casual leave to enable him travel to his hometown from Bauchi to his hometown in Cross River State to attend to urgent family issues. However, while on leave, he fell ill and was hospitalized. While on sick bed, he raised a signal to his commander notifying him of his ill health. However, the claimant was surprised to know that he was dismissed from service on 28th day of February 2026. Consequently, he traveled to Bauchi and met his commander, who said that there was nothing like signal received from him. The commander walked him out of his office and also commanded the provost marshal to follow him to his house, collect his uniform and also identity card. And that's how he was dismissed. The claimant wrote 3 letters of complaint. The letters were tendered in evidence and marked as Exhibit C1 to C3. Coming to the determination of the claim before the court, it has been established by a long line of decided cases that the burden of proof in civil cases, like in the case at hand, rests always on he who asserts. Therefore, the burden is on the claimant in this case to prove his case before the burden can shift. It is when he establishes his case that the burden can shift to the defendant. This is because the burden of proof in civil cases or matters is not static and may shift in the course of pleadings. In any case, depending on the state of pleading at various stages, the initial evidential burden of introducing evidence to prove a claim of legal right or liability based on the asserted fact upon which the right and liability are claimed. It does not shift pursuant to Section 133 unless the evidence has proved has discharged the initial burden. See the case of Adekoke versus Adibi. See also Oguaja, Ike versus Oguaja, Omodu Kaji versus Esegini, and UTC Nigeria Limited versus Philip. In the case at hand, the defendant failed to file statement of defense despite having been served with the originating process and despite having been served with hearing notices. In this case, the defendant ignored all the invitations by the court for him to enter appearance and file defense. The conduct of the defendant in refusing to honor the court processes served on them clearly shows that they are not interested in defending the case or that they do not have any defense to the claimant's action. The scenario that played out with the non-filing of defense is that the case is not being contested. In other words, all the claimants' averment and evidence laid at the trial are deemed to have been admitted by the defendant. The implication in the law is that the defendant or record are deemed to have accepted all the averments contained in the statement of fact as true and correct. Therefore, facts on unchallenged, uncontroverted are deemed admitted. See the case of Kolbo versus Police Service Commission. In the circumstances of this case, the court is only to grapple with the case of the claimant, as there is no defense filed to dispute what the claimant has averred before the court. See the case of Okoibo, in where Toby JSC of Blessed Memory has this to say. In this matter, the only case before the learned trial court was the case of the appellant. In law, he can stand or fall by his case. The respondent did not defend the action. In most cases where a plaintiff case is not challenged, he succeeds. This is because the trial judge has no other case to deal with other than the case stated by the plaintiff in his statement of claim. In his lordship continued at page 473. I quote, "The basic principle of law is that where a defendant fails to file defense, he will be deemed to have admitted the claim or relief in the statement of claim. But where a paragraph of the statement of claim is notoriously false to the common knowledge of the court, like 10th of July in Nigeria is independence anniversary, such a paragraph is not admissible because it is an obvious untruth." In this case, in the case of Egesimba versus Onwazuruke, the court said, I quote, "Where the only pleading filed is the statement of claim, absence of statement of defense means that no issue is joined." Per Ayola JSC as he won then. Therefore, the defendant's failure to defend the claim of the claimant means that they have no defense, as they have not disputed the claim of the claimant. The action of the defendant tantamount to admission. It is right law that fact admitted need no proof. See the case of Halaji Akali and Sons Limited versus NDIC. See also the case of CPAC Limited versus PBW Limited. See also Overseas Agency Nigeria Limited versus Brown Energy Travel Limited. The defendants failed or neglected to file statement of defense and has by law conduct by their conduct or failure to file defense have admitted abandonment in the statement of claim, which are left unchallenged and uncontroverted. See the case of Huawei versus Modiwo Nigeria Limited, United Nigeria Insurance Company, an insurance commercial and industrial company. The court, in such circumstances, has no choice or option but under an obligation to accept same as correct position of what claimant has presented before the court. See the case of America Cyanide Company versus Vitality Pharmaceutical Limited, reported in 1991 to Nigerian Criminal Report Part 171-15. It is the law that where claimant files his claim raising allegation of fact against the defendant, the onus is on them. Where claimant has his claim raising an allegation of fact against the defendant or one of them, such defendant who does not admit the truth of all the allegation must file a defense to contradict, controvert, challenge, or deny the said allegation. In the case at hand, the defendants failed and neglected to do so. By operation, although they are deemed to have admitted the assertions of the claimant, and the court may preemptorily enter judgment against them. See the case of Ajibade versus Mayowa. See also Oke versus Ayedun. See also Moshood Bayero versus Bayero. See also Emodi and others versus Emodi. In the case at hand, some of the reliefs being sought are declaratory claims, while the claimant will succeed on minimal proof. See the case of Adenebo versus Bayero University, Kano. A cursory look at the pleading and the evidence of the claimant will show that the claimant took 4 days casual leaves on 21st of September 2005. While on casual leave, he fell ill and he was admitted. And upon his discharge, he got no response. While still on his sick bed, he was dismissed from service on 28th day of February 2006 as a deserter. Consequently, he traveled to Bauchi to complain, but to no avail. The claimant claimed to be a police constable, but has not tendered any evidence to establish his status. Although a police constable has his appointment laced with statutory labor, in the circumstances, he is entitled to be treated in accordance with the rules and regulations governing his employment. The only way to terminate such an appointment with statutory labor is to adhere strictly to the procedure laid down in the statute. See where In the termination of unemployment with statutory labor, the employer flagrantly omitted to comply with the procedure for termination in the way and manner prescribed by any relevant statute. The termination is null and void and of no effect. See Olupega versus Abdurrahim. In the case at hand, the claimant has admitted taking 4 days casual leave but did not return to his duty post at the expiration of the 4 days casual leave. According to the claimant, he fell ill. He was hospitalized, but he never tendered any evidence before the court to establish his claim that he was hospitalized and remained in the hospital till 28th day of March 2006, the date he alleged he was discharged from the hospital. He also stated that while on sick bed, he raised a signal from either police station Ebonyi State to his commander, intimating him of his sickness. But no such radio signal was tendered in evidence, despite claimants pleading that he will rely on it at the trial. He also did not call any member of staff of the hospital to testify as witness to confirm his claim of being in the hospital for the period in question. In the case at hand, the claimant's failure to tender medical report concerning his hospitalization, failure to call any member of staff of the hospital to testify regarding his admission, or to tender any report from the doctors that have attended to him. Since there is no credible evidence before the court to establish absence of claim from claimant from his duty post from 26th day of September 2009, when he was supposed to resume duty after expiration of his 4 days casual leave, when on 28th day of February, when he allegedly stated that he was dismissed, the court cannot make any finding in favor of the claimant, as he had failed to prove his case by credible admissible evidence. The documents he tendered in evidence exhibit C1, C2, and C3 are letters of complaint. They are not capable of establishing the case of the claimant, as all that they can do is that a claim or complaint has been lodged by the claimant. There cannot be evidence to prove his case. The most important document for the claimant to succeed were not tendered in evidence. The document include doctor's report, radio signal. In view of my finding above, relief 1, which is declaration, cannot be granted in the absence of concrete admissible evidence in law. A declaratory relief cannot be granted, as the court must be satisfied that the claimant is entitled to those claims, as the duty is on the claimant to prove his entitlement thereto by cogent and credible evidence. He must rely on the strength of his own case and not on the weakness of the defense. See the case of Dumes Nigeria Limited versus Nwakoba and host of other cases cited there. Also, on improper cases, unchallenged and uncontroverted evidence have been held to be sufficient proof, where, however, in an instant case, the evidence is self-defeating and unacceptable, the court is not obliged to act on it. See Nwabuko. Also, on the relief seeking for an order mandating the defendant to immediately reinstate the claimant into Nigerian Army and into the Nigerian police force and promote him to the rank would be presently with his mate and payment of his entitlement of wages, salaries, and allowances. This relief is vague and unsubstantiated, having refused, and it is also a claim that is dependent on grant of relief A. Relief A having failed, relief B must also fail. For instance, since it is an ancillary claim which depends on the success on the main reliefs. The failure of the main reliefs also means failure of the ancillary reliefs. On promotion, the law is well settled that promotion of employee is not automatic unless where it is shown to be vindictive. Promotion is not a matter of course. It must be merited. The claimant has not adduced evidence to show he has met all the requirements of promotion, but he was refused. The claimant, having not proved entitlement to promotion, same is hereby refused. It is also to be noted that promotion from one level position to another in an organization is not a right, but a privilege which is earned. An employer cannot be compelled to promote its employee, no matter the good opinion of employee of himself. Promotion is neither automatic nor as of right. See Alberto. On claim for salaries, allowances from 2005 to date of the determination of this suit, this claim is vague, as the claimant has not even stated his salary per month and the allowances he is entitled to be paid. It is right law that a claim that is vague and lacks certainty is no claim at all. In the instant case, the claim for promotion, salaries, and allowances is uncertain. The claimant did not state with certainty what his salary and allowances are, where and how he earned these promotions or this entitlement. These vital facts were backed all the reliefs pertaining to promotion, allowances, entitlement, being reliefs that were vague, uncertain, being reliefs that was vague, uncertain, and lacking in particulars, and proof by evidence must fail. See the case of University of Jos versus Dr. Ike Goha. The failure of relief A and B means relief C cannot also succeed. As a general rule is that reliefs the claimant having willfully failed to prove the main claim is not entitled also to 50 million naira damages as claimed. From all I have been saying above, the claimant has willfully failed to prove entitlement to any of the relief sought. Consequently, his case failed. Same is hereby dismissed for lacking in merit. I have made out the claimant has from all I have been saying, the claimant has woefully failed to prove his entitlement to any of the relief sought. Consequently, his case failed, and same is hereby dismissed for lacking in merit. I make no order as to post parties to bear their respective cost.
As the court pleases.
As the court pleases.
Call the next case.
Suit number NICN CA 12/2022 between Mr. Christopher Okoro and EcoBank PLC. My lord, the parties are absent.
Parties absent. Appearance.
Hey, please, my lord. Dr. Emmanuel Sani,
Yes.
my lord, I appear for the claimant.
Yes, any other appearance? Any other appearance?
Apparently, the defendant is not online. But my lord, we had filed.
My lord, with humility, S.O. Honor appears for defendant, my lord.
Yes. Yes, Dr. Sani, you are saying?
Okay, I thought I was thinking the defendant was not online.
Yes.
My lord, pursuant to the order of my lord,
Yes.
we have filed our address on the issue of jurisdiction raised so moto by my lord. My lord, we filed on the 7th day of July, 2026, my lord.
Yes.
My lord, we adopt and rely on same as our arguments, our expressing our position on the issue so raised. You urge my lord to find and hold that my lord has jurisdiction as the case is properly constituted within the exception recognized and pronounced by the Supreme Court in the case under consideration. May it please my lord.
Yeah. Yes, Mr. Honor.
Yes, my lord. My lord, we qualified on the 7th day of July, 2026. The issue of jurisdiction based on the Supreme Court's judgments, which are in the case under review, my lord.
Yes.
My lord, we adopt our arguments and rely fully on the judgments in submitting that the industrial court has no jurisdiction, because the principal claim in this suit is not labor related, my lord.
Yes.
May it please, my lord.
You see, counsel, you have not dealt with the issue I raised properly. I said, having regard to the recent decision of the Supreme Court and the Court of Appeal decision, what is the impact of the decision of the Supreme Court on the jurisdiction of the court to entertain this matter based on the judgment of the Court of Appeal? But you were all silent on that. Well, whatever the case, I will consider the submissions, then I make up my mind and take my position on that. So I will communicate date reserved for decision to counsel.
I'm most grateful, my lord.
Okay.
As the court pleases, we are most obliged, my lord.
Yes, date will be communicated to you.
As the court pleases.
Very well, my lord.
Okay. Thank you very much for your. I have read, although I have already read your submissions. All the submissions were lifted from the HP decision.
Yes, my lord.
It's all right. I will consider everything and now take a decision on it. I will consider the Court of Appeal decision, the Supreme Court, the HP case, and your submissions. Then make up my mind. I will communicate that for you.
As the court pleases.
As the court pleases, my lord.
Yes, Registrar. Any other matter?
Yes, my lord, there's a garnishing matter, 20M, 2026.
You said?
20M is a garnishing matter, my lord. They've all filed. I sent the
Okay.
file.
Okay. Call the case.
Yes, my lord. Suit
Dr.
number
Sani and
NIC.
Ona, you are free to go. And you are free also to remain if you want to remain.
As the
My
court
lord,
pleases.
I don't know whether I'm in the garnishing matter because she said 20M. I thought they said 27.
And when she called the matter now, if you are in the man, she must have served you. And you must have known the date because it was adjourned in open court.
No, this one I was just told yesterday about it. One of the...
Well, let her call now. If you are in the matter, you announce your appearance.
Very well, my lord.
Call the case.
Suit number NICNCA 20M 2026 between Mr. Jim Ogumiri Oyuk and 1. Comptroller General, 2. Nigerian Correctional Service, 3. The Assistant Comptroller General of Nigeria Correctional Service, Owerri, Imo State, 4. The Comptroller of Corrections, the Nigerian Correctional Service, Cross River State Command, 5. CSC Ilo Moses A, 6. CSC A Ofem, and 1. Central Bank of Nigeria, 2. First Bank of Nigeria PLC, 3. Keystone Bank PLC, 4. United Bank of Africa PLC. My lord, all the parties are absent.
My lord, I
Appearance.
meant to take my leave, my lord. It's not the matter.
It's all right. You are welcome.
Thank you. Thank you, my lord.
Appearance.
With utmost humility, my noble lord, Okeme Jerome.
I can't see you. I can't record you if your video is off. You have to on your video. This court sitting, please. If you want to be recorded and you want to be heard, you must on your video. Yes, any other appearance?
Yes, my lord.
Counsel, you have to unmute yourself.
Yes, my lord. I'm for one of the garnishes, my lord.
Yes.
My name is D.O. Unduanusi, my lord.
D.O. Indubusi.
Unduanusi spelled N-D-U.
Induanusi.
Yes, my lord. N-D-U-A-N-U-S-I.
Are you for who? Counsel, your network is not good. You appear for
My lord, for the third garnishi, Keystone Bank, my lord.
Okay, third
D.O.
garnishi.
Unduanusi. Yes, my lord. Keystone Bank.
Okay.
Thank
Yes,
you, my lord.
any other appearance?
Yes, my lord.
Yes.
Please, my lord, to hear Basi Otu. My lord, I
Basi
appear for.
Otu.
Yes, my lord, Basi Otu.
You appear for who?
My lord, for the second Ganishi, First Bank.
Yes, any other appearance? Any other appearance? Yes, Induanusi. You are post dependent.
Yes, my for the third garnishi, my lord.
Okay, Garnish, sorry.
Yes,
Third
my lord.
garnish.
We filed affidavit to show cause on the 30th of June, my lord.
Okay, on 30th of June.
Yes, my lord.
Yes.
My lord, and we stated that the first 4 defendants do not maintain any accounts with the third garnishi.
Okay. Yes.
My lord, we further stated that the 5th and 6th garnishi have their names have abbreviations, and we could not properly identify them. We requested for
6 and 7.
the 5th and 6th judgment debtors.
Okay, the 5th and 6th.
Yes, my lord. They have abbreviations in their names.
Respectfully, my lord, sir. Yes, sir.
They have their name abbreviated.
And
Respectfully,
we,
my lord, who came.
Counsel, you cannot interrupt me when counsel is making submission.
I'm sorry,
We
my
are
lord.
in court. You have to allow counsel to finish
I'm sorry, my lord.
before you can interrupt.
Sincere apologies, my noble lord.
Yes, Indubusi.
honestly, my lord, we therefore require further information, further particulars of the 5th and 6th judgment debtors.
Okay. Yes. So what are you praying for?
Not for us, for the third garnishi to be discharged, having obeyed the order of this court. May it please, my lord.
Yes. Yes, counsel.
Sincere apologies to my noble lord. My lord Ukeme Jerome. Ukeme Jerome,
Yes.
my lord. For the first Ganishi Central Bank of Nigeria, my lord.
Yes.
My lord, we have filed affidavit of compliance before a 6-paragraph affidavit of compliance. And
Yes.
we've also disclosed that the first, third, fourth, fifth, and sixth judgment debtors do not maintain account with us with the first Ganishi. But
Okay.
however, the second judgment
Yes.
debtor
Yes. Yes, Mr. Jerome.
maintains
Mr.
that
Jerome.
be attached to settle. They said yes, my lord, that we have this.
Yes.
My lord, we have said that this week there are the funds within the first Ganishi can settle the judgment sum, my lord.
Yes, I recorded you.
Yes, my lord.
Yes,
We await the
Mr.
necessary order of the court so that we.
It's
My
all
lord, we
right.
await the necessary.
Mr. Bassi.
Yes, my lord. My lord, the second Ganishi has equally filed her affidavit to show cause, my lord, on the 30th of June, 2026.
When?
Lord, it's an my lord, on the
When did you
30th,
file?
filed on the 30th of 2026. My lord, it's an
Yes.
affidavit of 7 paragraphs.
Yes.
My lord, the second Ganishi has disclosed that none of the judgment debtors maintain an account relationship or have any funds with the second Ganishi. Consequently, my lord, we humbly pray the court to discharge the second Ganishi, First Bank,
Yes.
from these Ganishi proceedings, having obeyed the order of the court. May it please my lord.
Okay. No appearance for fourth Ganashi. No appearance for fourth Ganashi, and no appearance for the judgment creditors. This is my ruling. Let me write my ruling. Yeah, this is my short ruling. I have perused the affidavits filed by the garnishes to show cause as per the order NISI made by the court. It is clear to me that from the affidavit evidence, the second and third garnishes do not maintain account for the judgment debtors, and in the circumstance they do not have any funds of the judgment debtors with them. In the circumstances and in view of the disclosure made, the second and third garnishes are hereby discharged. From the affidavit filed by the first garnish Central Bank of Nigeria to show cause, it is unequivocally stated that the second judgment debtor maintain an account and has sufficient fund in the account to defray the judgment sum. In the circumstances, the order NASI hereby made by the court is hereby made absolute. The first Ghana Central Bank of Nigeria is hereby ordered to pay the judgment sum attached as per the order NISI, which has now been made absolute, to the judgment creditor, which sums are in two tranches. in 2 tranches of 1.3 million and 500,000 naira. The Central Bank of Nigeria, who is the first garnishee, shall be discharged upon payment made to the judgment creditor and evidence of such payment lodged with the registrar of this court for the record of the court. Ruling is entered accordingly.
As the court
As a
please.
court, please.
So please, Mr. Jero. Mr. Jero.
My lord, I think he's disconnected, my lord.
Yes.
Okay.
Okay.
Yes, I can't see him. It's all right.
Thank you very
Thank
much,
you very
my lord.
much, counsel. We have come to the end of today's proceeding. Thank you for joining. I wish
All right,
you
my
all the
lord.
best. Good night.
Thank you, my lord. Thank
Thank you, my lord.
Registrar, any other matter?
No, my lord, that's all for today.
Okay, thank you.
Thank you, my lord.
Mhm.